ऑडिबल है?
यस मैम।
थैंक यू, थैंक यू, थैंक यू। वंदना, सभी को म्यूट कर दो अभी। थैंक यू सो मच। वंदना, संगप्रिय, सभी को म्यूट कर दीजिए प्लीज। वेरी वार्म गुड इवनिंग टू ऑल. नमस्कार. Today we will delve into a very important topic of criminal practice. Now, criminal practice starts from the basic complaint, and this basic complaint first, as everybody knows, goes to the police station. Now, when you go to the police station, it's a simple application describing all the facts, also the evidence if you have anything, and you can also give the witnesses' names who were has witnessed that incident. Now, this is to beginning of the case, but sometime the police may or may not register the complaint. But the complaint should always be in writing. It can be in oral also, because if serious crime happens, you can't write the complaint and then go to the police station. It's not possible. But mostly, I would suggest it would be better if it is in writing. But in serious crime of offenses, rape, or some would say murder, or something bigger, dacoity, theft, you can't wait to write the complaint. So mostly it will be in the beginning, it will be an oral, and later on you can give in writing. But mostly it is an oral complaint in the beginning of the some heinous crime or serious crime. Now when you go to the police station, there is a possibility that police may not register your complaint. Then what do you do if they do not register the FIR? In such cases, there are other avenues, other way to get it registered. That is what we will discuss in the today's lecture. Now, the first and foremost is the complaint. That is basic. It may be oral or in writing. Writing would always be preferred in comparison to the oral. Now, when you give a writing complaint, always give take an acknowledgement from the police. Now, when you give complaint, what happens if the police finds it? It's a cognizable offense. Then they will register the FIR. That is first information report. Now, if FIR is registered, your work is done. But there is a possibility that if FIR is not registered, then what you do? That is the most important part of today's lecture we will be discussing. When FIR is not registered and you know that a crime has been committed by that opposite party and you want to get it registered, then what you do, you can give in writing to the police, and also the police station, the local police station, if do not register the complaint, then you go to superintendent of police or here commissioner of police, ACP or DCP. You give in writing the CC2 to everybody that this is the complaint I have given and this is not registered. And possibly the higher authorities at the police will take cognizance. But this happens that they also do not take the cognizance of your complaint because they do not find any substance. Now, what happens after this? The only way is to approach the lawyers. That is where our role comes. Our role can be in the beginning also in drafting the complaint also. The police complaint is also to be drafted very properly. Now, if the client comes to you, the only option after the police station visits and when the police do not register the complaint, and you also see that the cognizable offense has taken place, so you can complain before the concerned magistrate of that area, that is JMFC or the Metropolitan Magistrate Court. Here you file a complaint, and here the magistrate, you have to give all the facts, argue your case, and the magistrate will order for registration of FIR, that is under 156(3) of the old act, this criminal procedure code. It is 156(3) CRPC का order लिया कि ऐसे normal बात होता है. Now what happens when the magistrate gives an order, the police has to register an FIR, that is first information report. But here there will be two things I would like to add. Now FIR and CR is one and same. those who are into criminal practice should know this. The FIR and CR is same. When it is in police station, FIR, and when it comes to in remand, that is the person is arrested and brought to the police station, brought to the court, it is called the remand. Remand, the that proceeding is called remand. Remand pe laya hai. Now here we say CR is the registered crime registration number. Now the FIR number, CR number is the same. Now, what happens when the court orders to register an FIR? The police officer, it is obligatory and mandatory on his part to register the FIR because there is a court order. Now, this FIR is called MCR. If you anybody of you right now have an FIR, just look at it. Those who are lawyers, they will know it better. That once you FIR is registered on the order of the magistrate, it is called MCR, magistrate CR, because the FIR word is just, I would say, they cancel it and they write MCR over the same in a small wording. So they know that the offense is been registered on the order of the court. Now this is the difference between MCR. So MCR is very not very regular word. Mostly it is FIR is a registered and cognizable offense. Now what happens when the court also says that no cognizable offense has taken place? So what they will do, they will send the police and for the inquiry and report and order for the inquiry and report. That is called INR, inquiry and report. They'll call police report. Why you're not investigated? Why you're not registered? Then police will file their report saying that this is the reason. Sometimes police may say yes, we can register the FIR because there is cognizable offense has taken place. Now we got some material from the complainant. They will record the witness's statement. If that comes, again an FIR is registered. That is MCR. But sometime what happens, the police also files negative report. Even the court says that no cognizable offense has taken place. In those cases, summons will be issued. In those cases, summons will be issued from the court. So it will be treated as a private complaint. It will not be a state government matter because see, always we say prosecution side is a state case. Now here it will be because you will a state of Maharashtra versus XYZ. You will always read in judgment state of Maharashtra, state of Punjab and Haryana. Okay. Now next is NC, that is non-cognizable offense. Suppose the offense is too petty, just it is a matter of some scuffle between two people and nothing has happened, major nothing has happened. In those cases, the police say it is a non-cognizable offense. Suppose husband and wife fights and they go to the court, go to the police station. In those cases, it will be just a non-cognizable offense. So in a non-cognizable offense, it will be NC. They will write a small sheet, write the NC number and give it to you. And with that NC, also you can file a private complaint before the court and get the summons issued also. Or because you are aggrieved that NC is registered, but there is a cognizable offense. Again, you can go to the court and say, no, it's a cognizable offense and I'm praying for 156(3) CRPC order. Now, under new law, it is 175, but more or less it is same. There are some more documents asked now when these matters are taken to the court. So complaint, FIR, MCR, NC, these are the basic private complaint, basic of the opening of the criminal law, which is put into motion. So this was a small topic, but I would like to discuss one case
सर
here.
फ्रंट कैमरा अपना ऑन कर रहे हैं, बोल रहा है यू कैन नॉट स्टार्ट योर वीडियो बिकॉज द लॉस्ट हैज डिसेबल्ड इट।
सर
ऐसा
मीटिंग के बीच में मत बोलिए सर, प्लीज बाद में बोलिए. Now here I am discussing one case, Sakiri Vasu versus State of UP. It is a Supreme Court's case. Now Justice Markandeya Kaju is the author of this judgment. Now in this judgment, what see, if you I want to seize all of you, it cites 24 cases and cited by 8,229 times. It means that this case was cited so many times. Now in this case, what happened, that this appellant who has gone to the court. Was the father of a person who was serving in army as a major. Now his son died in a suspicious situation. Now there was a court inquiry, but at the level of the army. Now, what the report of the army was that he has committed suicide. There was evidence record. He has committed suicide. But the father of the that this dead person, army personnel, he was thinking, no, no, his son was murdered because he had made some oral complaints about the corruption. Now, because he was not satisfied that because no FIR was registered, he went to the uh, first to police, then no FIR was registered. Then he went to the Allahabad High Court because the offense is taken at Mathura railway station. And now, when he went to the Allahabad High Court, he was requesting under writ jurisdiction, requesting for the CBI investigation. But then Allahabad High Court rejected his writ and then say you have got other avenues, other way to do get it done. That is 156.3 CRPC that time. Now, as he was not happy with the Allahabad High Court, he went to the Supreme Court. Supreme Court also said the same thing that you cannot, number one, you cannot choose the which investigation agency will look into the matter. It is either the court or the police will decide on the gravity of the matter. This is what has happened. Now, second thing, the same thing which we repeated in the beginning of the lecture is said that if you have a feel that there is a cognizable offense, first you have to go to the police station. Then police does not agree, then go to the senior officers, maybe superintendent of police or the commissioner of police, ACP, DCP of that area. And if they also do not register the FIR, then you can go to the concerned local magistrate court under 156.3 CRPC. This I'm talking about that time. Now it is 175 of the BNS under the new law. So this judgment is very, very important. I will request Vandana to put this into the group as well as the WhatsApp chat group. Read this judgment. It will give you an idea what I was talking in the beginning of the case. Now to over to Aditi for reading the judgment. Kindly unmute yourself. Everybody will keep their mic on mute. Let Aditi read it. Just a minute, Aditi. It's a Dilawar Singh judgment. Again from a Supreme Court. Aditi, can you see the screen?
Yes, Sanya.
Yes. Start from this. One, challenge in this appeal.
Challenge in this appeal is to the judgment of the learned single judge, Delhi High Court, dismissing the appeal filed by the appellant and affirming his conviction for offences punishable under sections 452, 392, 397 of the Indian Penal Code, 1860, and sentencing him to undergo 1 year, 2 years, and 7 years.
Aditi, little louder.
And sentencing him to undergo 1 year, 2 years, and 7 years rigorous imprisonment, respectively, with fine in each case with default stipulation. The sentences were directed to run concurrently. Prosecution version in a nutshell is as follows. Complaint was filed by Balwant Singh, alleging as follows. On 8th August 1984, he was sitting at Kali Mata Ka Mandir, Udasin Ashram at village Saharpur, Shahadara, Delhi. He acts as a priest in the temple. Donations were collected from various persons to build the temple, and he was maintaining the temple. He was residing at the temple and performing regular puja on 8th August 1984. At about 9:30 p.m., after performing evening puja and arti, and after having dinner, he was doing meditation when 5 persons, including 2 accused persons, namely the present appellant and one Ram Saran, and 3 persons who were Sikhs and whose names he did not know but could identify them, entered into the temple, tied him with a rope, and ran away with a donation box with cash of about rupees 5,000. Appellant was carrying a knife. Ram Saran was having a lathi, and one of the three others, who was a Sikh, was having a revolver. After some time, two local persons, namely Kanwar Singh and Dr. Salek Chand, came to the temple, and they also saw five persons running towards Gagan Cinema. Both of them identified the appellant and Ram Saran. They untied the rope and cried for help. After hearing the cry, several local residents gathered at the temple, and the complainant narrated the whole incident to them. Complainant, along with conversing and Dr. Salek Chand and others, went to lodge report at the police station, Simapuri. But the duty officer did not listen to him, and the local residents and directed them to go away. On 9th August 1984, complainant made a written complaint to the Prime Minister, police officials, but to no avail. Therefore, the complaint was filed on 31st August 1984. After going through the evidence, the learned magistrate came to the conclusion that there was material to proceed against the appellant, Ram Saran, and three others. He committed the case in the Court of Sessions as offence relatable to Section 395 IPC is exclusively triable by that court. Accused Dilavar Singh pleaded innocence. Ram Saran died during the proceedings and the charges against him were dropped. Except PW1, no other witness was examined. It was stated by the prosecution that Dr. Salesh Chand, Kanwar Singh, and others could not be traced despite the liberty granted to the prosecution. The trial court found that the delay in making a grievance has been explained and complainant's version was acceptable. The appeal before the High Court was dismissed by the impugned judgment on the ground that PW1's evidence was clear and cogent. In support of the appeal, learned counsel for the appellant submitted that the alleged incident took place on 8th August 1984 and the complaint was lodged on 31st August 1984, except a bare statement to the effect that representations were made to various persons, but no material in that regard was adduced. Further, the modalities to be adopted when the police does not register the FIR are indicated in section 154 subsection 3 of the Code of Criminal Procedure 1973. Admittedly, that has not been done. It has also not been explained as to how and why the Prime Minister of the country was moved. Even no material has been adduced to show that any such complaint was made either to the Prime Minister or the police official claimed. In any event, no advocate was engaged for the accused who did not have the means to engage a lawyer, and therefore the mandate of Section 304 CRPC has been clearly violated. In any event, the ingredients of Section 397 IPC have not been established. Learned counsel for the respondent, on the other hand, submitted that mere delay in lodging the complaint does not in any way affect the credibility of PW1's version. The evidence of PW1 is the only material on which the conviction has been recorded. In court, his statement was that accused appellant and Ram Saran were holding knives and other Sikh accused were holding lathi. But in the complaint, it was stated that Ram Saran was carrying a lathi and one of the accused Sikh was holding a revolver. It was accepted that no injury was inflicted on the complainant by any of the accused. The effect of not adducing material to show that, in fact, the grievance was made before the police and the FIR was not recorded has been considered by this court in several cases. Section 304 CRPC mandates that when the accused is not represented, the court has to appoint a counsel so that the accused does not go undefended. In criminal trial, one of the cardinal principles for the court is to look for plausible explanation for the delay in lodging the report. Delay sometimes affords opportunity to the complainant to make deliberation upon the complaint and to make embellishment or even make fabrications. Delay defeats the chance of the unsolved and untarnished version of the case to be presented before the court at the earliest instance. That is why, if there is delay in either coming before the police or before the court always view the allegations with suspicion and look for satisfactory explanation. If no such satisfaction is found, the delay is treated as fatal to the prosecution case. In Tuliakali versus the state of Tamil Nadu, AR 1973, Supreme Court 501. It was held that the delay in lodging the first information report quite often results in embellishment as a result of afterthought. On account of delay, the report not only gets bereft of the advantage of spontaneity, but also danger creeps in of the introduction of colored version, exaggerated account of concocted story as a result of deliberation and consultation. In the Ramzag and others versus the state of UP, AR 1974 Supreme Court 606, the position was explained that whether the delay is so long as to throw a cloud of suspicion on the seeds of the prosecution case must depend upon a variety of factors which will vary from case to case. Even a long delay can be condoned if the witnesses have no motive for implicating the accused and or when plausible explanation is offered for the same. On the other hand, prompt filing of the report is not an unmistakable guarantee of the truthfulness or authenticity of the version of the prosecution. The complainant has attempted to explain the delay by stating that the matter was reported to the police, but the police did not take any action. Such statement can hardly be taken to have explained the delay. It is the simplest of things to contend that the police, though report had been lodged with it, had not taken any steps, but has to be established by calling for the necessary records from the police to substantiate that, in fact, a report with the police had been lodged and that the police failed to take up the case. The principle has been statutorily recognized in Section 210 of the CRPC, which enjoins upon the magistrate, when it is made to appear before him, either during the inquiry or the trial of a complaint, that a complaint before the police is pending investigation in the same matter. He is to stop the proceeding in the complaint case and is to call for a report from the police. After the report is received from the police, he is to take up the matter together, and if cognizance has been taken on the police report, he is to try the complaint case along with the GR case as if both the cases are instituted upon police report. The aim of the provision is to safeguard the interest of the accused from unnecessary harassment. The provisions of Section 210 CRPC are mandatory in nature. It may be true that non-compliance of provisions of Section 210 CRPC is not ipso facto fatal to the prosecution because the provision of Section 465 CRPC, unless error, omission, or irregularity has also caused the failure of justice, and in determining the fact whether there is a failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings. But even applying the very same principles, it is seen that in fact the appellant was in fact prejudiced because of the non-production of the records from the police. Delaying filing the complaint because of police inaction has to be explained by calling for the records from the police was explained by this court in Kedu Moharton and others versus State of Bihar. AIR 1971 Supreme Court 66, where the court took exception to the fact that the complaint lodged with the police had not been summoned or proved. No satisfactory proof of any such complaint had been adduced before the court, and none of the documents as would have become available under Section 173 CRPC had also been brought on record. When information is given at the police station, normally two courses are open. A station diary entry can be made or the FIR registered. In case there is any deviation, recourse to Section 154, subsection 3 has to be made. If that does not yield any result, a complaint can be filed. Section 156 reads as follows. Police officers' power to investigate cognizable cases. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station will have power to inquire into or try under the provisions of Chapter 13. No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Any magistrate empowered under Section 190 may order such an investigation as above mentioned.
Wait. Thanks, Aditi. Very well.
Welcome. Thank you, ma'am.
This is one of the important judgment. It is also mentioned in the case of Sakiri Vasu, do read it. I'll ask Vandana to put in the group. Because 156.3 and the new 175 is not very different. If you know the basic laws, it all continues. Now we'll go next to the legal vocabulary. First is fortuitous, unexpected. Now the petitioner's promotion was not a regular promotion, but fortuitous promotion. Now when you say like this, it is unexpected. Rarely use word, but let it be with you because sometime you can use this word. Now next is foremost. Now this is very regular word, predominant or important. The Chief Justice identified trust as the foremost challenge facing institutional arbitration in the country. Foremost challenge, very important part. Backdrop. This is the most important word I would say because you can use this word while arguing also and while writing and drafting the this any petition also. Mostly I use in matrimonial dispute. Situation, circumstances. The principal CIT. Those who are in the criminal this tax practice, they will know what is CIT, Commission of Income Tax. The principal CIT, thus in the background of his aforesaid conviction, initiated proceeding. Situation of aforesaid conviction. Dismay. You can call nirasha in Hindi. Sad disappointment. We must at this point also express our deepest dismay at the role of Union of India in this matter. Now here I think the judge is telling these words that we must at this point, the judges are telling in the High Court level, express our deepest dismay at the role of Union of India, this government in these matters. This may public PL matter, PIL. Bold expression. That is plain, without any evidence or something. Bald expressions without any supporting material would not be sufficient. Reiterate. You can understand the meaning. Restating. She had reiterated the contents of a statement of claim in her written statement. Anomaly. Discrepancy. There is no pay anomaly between the petitioner and respondent. Therefore, the question of rectification. The rectification means correction. Or pay anomaly does not stand because it is same, not inconsistent. Felony. The art of committing a serious crime. Act of committing a serious crime. It is not always necessary that the complainant or the informant, see complainant, another name is informant, because there is a possibility that complainant may not come personally, then informant. If the child is minor, the mother and father may be informed or some relative also. Is also victim, for even a stranger to the act of crime can be an informant. And similarly, a victim need not be a complainant or informant of a felony. Per contra. On the contrary, this is also very regularly here in the High Court and Supreme Court by the designated lawyers. See, per contra, the contention raised on the side of respondent is that the remand of the petition is relatable. Next is version. To tell or impart information. Version. What was his version in the court? 4 different versions have been given by different witnesses, disclosing the genesis of the main incident. This was all. Now we go to next practical thing. That is the what are the options available to the lawyer. One option everybody knows is the regular practice before any court, any tribunal. But sometimes there are cases where there is a reason behind not practicing, because I encourage people to go into litigation. This is what I prefer, but there is a possibility somebody wants a fixed income, somebody wants to 9 to 6 job, and some are not comfortable practicing before the court. Now there are so many things apart from the practice which I will say. but some things are permanent. Like if you're a government pleader, that is a, if you are now see government pleader and public prosecutor, there are two parts. So public prosecutor you can say for the criminal side, and government pleader is for the civil side. You have a choice to appear for these exams to become a government pleader or to a public prosecutor. Now when you go as a public prosecutor or government pleader, I would say you get a lot of exposure, because as a government pleader on the civil side and as a uh, public prosecutor on the criminal side, you if you're in one court also, you get 40 to 400 cases per day to go through. So you get a bigger exposure. I would say it is one of the best career. If you are looking at it in the beginning of your career, it will give you a lot of knowledge, lot of confidence, because whole day you're in the court. One, number two, you get to read so many briefs. If you go to any private lawyer, he will have 10 cases, 20 cases, 100 cases, maybe in some people 3000 cases. But sometime it is possible that when you become a public prosecutor or the government pleader, you are bound to get so many cases, and you're going to have that much exposure where it will be different kind. Secondly, you appear every day before the judges, so you understand that part also, how the judges mind work, how they give the orders. Also, as a public prosecutor or government pleader, in if you are appearing in 40 cases, opposite are again a 40 lawyers. So you know that many lawyers, you get to hear those many lawyers also. So whenever I tell my juniors, and always all of you also, whenever you get a chance, any go to any nearest court, just sit there. The public prosecutor or the government sits from morning to evening. You also sit, and you will have a exposure to that 40 cases or 400 cases. You may not be having hand on their papers, but at least you will hear what they are telling. Now, next part is the panel advocate. This is very lucrative part of the practice. Now, here what we see, that you are on the panel of either bank or any company. Also, there are companies which take you as a retainers also, but you need to find out these people. Now, for panel, if it is a government panel, mostly the advertising comes. Nowadays, WhatsApp groups are there, so they provide all the information there also. You need a lot of documents, certificates, and also the experience, because anybody, any bank or any company or any government PSU, public service department, they will be appointing you. They will want that you understand the background of the case, you know how to appear before court, how to argue before the court, how to draft. This is a, I would say, panel advocates, they require a bigger quality of the expertise in the legal field. If you are expert, then they will employ. There are interviews, there are sometimes written exams also. So mostly it is an interview of a panel of the lawyers or panel of the from the company, that is a government department. They will interview and they will take you on the panel. Now this is also very important part. If you're on the panel of the bank, there also you get lot of experiences. When you get lot of experience, trust me, it also helps you so much to, I would say, you there also you get lot of exposure, and you handle so many cases. Here you get to know with the people also, you get to know the banks or the, and they will also in return, they, if your work is good, they will also give you cases of other kind. It may be matrimony, it may be making a will, it may be criminal case, it may be civil case. So if you're on the panel of the bank, your work is good, they will also give you other works. So it is a actually a good network. Now next is like some people want to work in a companies. Now there are so many companies, we employ the interns also, these also employs as a legal officer. Here also advertisement comes, you can find out from the online or the WhatsApp group. Now when you go for these companies as a legal officer, the job will be 9 to 6 job or whatever their way of working. Here, one important thing I would like to tell you, if you are a legal officer in a company, then you will not be treated as a lawyer. There is a recent judgment by the Supreme Court. You can't be a lawyer, you will be legal officer. In fact, you will be assisting the lawyer who is in the court representing your company. So you will be a link between the company as a legal officer and the lawyer hired by the company. You will be informing everything on behalf of the company. The company will not come. Company people, the main directors and the chairman will not come, and vice president, they will not come. You have to, on behalf of the company, inform what is the course of action the lawyer is taking, and the lawyer has to take, or you can guide also that this is the position of the company. This is also very important position as a legal officer. But one request, see, anything which you do, take one or give 1 or 2 years. Don't go every 2 years, 2 years, 2 years. This first you should decide from the beginning where you want to go, and if you don't know how to go, give it a try, or speak to some senior, because 2 years, 1 month, this will not give you. You will be wasting your time, precious time. And the 25 to 35, what you do will decide your future course of practice. It's not you're going to start your practice at 35. Though I'm sorry, but those who are starting at 35, 40, it takes time. See, lawyership takes time to develop practice, 2 years, 5 years. Yesterday also, one person who has just started, he was saying, I have read so much. I appreciate that he has read so much. Then he is drafting, he was asking the basic questions to me. I was very happy. But then it requires lot of efforts. It's not that if you start late, you can't continue. You can continue. But then there will be, you will be little bit lagging behind the other people, but that you should not frustrate you. You should not feel that why I'm lagging. Because see, in the legal field, I will say this month you will not get any case, but next month you will get two case also. So this is a possibility. You have to keep on reading. You can use library, you can go to the bar room, you can attend the online lectures. There are so many things. There are judgments on the legal portals where you can read. So it is a developing career at the end of your life. So this was what for all of you. Anybody have a question, let me know.
Good evening, ma'am. Can I ask a question?
Yes, yes.
Well, this is pertaining to the last session that we had yesterday. That this is on plaint drafting, actually. Can I go ahead?
Yes, yes.
Madam, I've seen the petitions and drafts where uh, the advocates have drafted in a way, they have pleaded in a way which includes bullet points. And then there are paragraphs also. So, in your opinion, which is a better way, drafting in bullet points, numbering them, or going by the paragraph?
If it is
Because,
a, see, if it is a plain no, in CPC there is a specific provision for that, how it should be drafted. Which code
right,
you are talking about? Local code?
I'm talking about, say, for example, if I were to draft a petition in Bombay High Court, so
Which
there is,
kind of
then there is,
petition you're talking about?
it is 220, under Article 226, writ jurisdiction.
Writ petition. Okay.
Writ petition.
Let me tell you something. For writ petition, there is no such format, fixed format. There is no fixed format. You
So we
can,
can include both.
yes, you can. There is no fixed format. For writ, there is never a format. For SLP, there will be a format. For plaint also, there is a format. This is the way. But no, there will be cause of action, all that. I'm not a very good authority on the civil, but I will tell you there is a way to write the plaint.
Okay, ma'am. One question from today's lecture on the options to be options for a lawyer. I have heard a term which is many a people, many advocates, they call themselves arguing lawyer.
Arguing,
Argu-
arguing counsel.
Arguing
See,
counsel.
arguing
So
counsel, it
how
means,
can we be that, and what are the qualities and what may be the experience
see,
required?
arguing counsel, if I see, if you file a case and you call me tomorrow, I can be say I'm a arguing counsel along with Mr. So and so. It is like that. It is, there is nothing different. Arguing counsel, you become a little bit senior and somebody engages you, you say that I'm an arguing counsel. Normally, this term is used in the Supreme Court. But they must maybe using who is the, I have filed the case and he is the arguing counsel. You can say that.
Okay.
There is no other stuff. There is, see, there are only three types of advocates according to the main basic part is advocate, senior advocate, and there is a one type advocate on record, which is, but mostly is advocate and senior advocate.
Okay.
So,
Okay, ma'am.
Good evening.
good evening.
Good evening, madam. My name is Mahendra Reddy from Telangana State, madam.
Okay.
So regarding the career part, after the LLB course, so what will be the best for the next generation for like that? So it's a litigation is better than other fields, madam. Could you suggest which will be the best?
As I have said in our lecture also today,
Yes,
that
ma'am.
litigation, I would say, is a very comfortable part. Anytime it can be started, anytime you can go back. And for
Ma'am.
ladies here, I would say it is the one of the best part for the lady advocates, because there is a possibility they deliver baby, they get married to other places. Everywhere,
Yes,
every 30 kilometers, you will find the courts in India. So according
ma'am.
to me, because I am a litigation lawyer, I always feel that litigation is better. And I have
Yes,
seen
ma'am.
few friends here that they have gone as a legal officer, they have gone as a in these government jobs, and they came back to the litigation. So afterward it was actually difficult for them, so it's better. uh, it's everybody's choice, but I feel litigation is the best, because litigation is something which you can go and come back, but litigation is something we can't learn at a later part of the life. You can, but then it requires a lot of efforts. Just because you have a age where you can just submit, it's not like that. Law is a continuous study.
Yes, ma'am. Thank you so much,
Uh,
ma'am.
Madam, can I also ask a question?
Yes,
Another
yes,
one.
yes.
This is in general. I just wanted to thank you for sharing the vocabulary and everything what you said. I have practically implemented it personally. So, ma'am, can we expect a detailed session, another kind of internship or whatever the session on the detailed topics?
Detailed topics, I'll be holding it. I had hold so many I've done in the corona period. There are if you have subscribed to my YouTube,
Yes,
you will find the old all the lectures. There's a
right.
last in theory criminal trial stage which was recently done. On revision review also happens, there is a detailed lecture. So if you can go through them, it will. On cross examination there are, I think, 4 videos. It will help you. I'll try to put all the 4 cross-examination videos in the
And
group, and we'll
seen
be
that, but
having detailed session later. Later.
seen that, but still I haven't gone through that. But I must thank you, madam. I learned a lot from this session. Thank you.
Okay, okay.
Hello, ma'am. Good evening. This
Good
is
evening.
Vinay here. Vinay
Yes,
Kumar
yes.
from Telangana State, ma'am.
Okay.
So my first question would be if we want to pursue a career as a lawyer or into the contracts field mostly, right? Where
Okay.
we have less risk, I would say, when we are starting, well, in the initial stage, right? So what will be the career options while being part of an organization? How can we get into the legal cell or legal suggestives of that particular organization? Is there a way that we can move within?
See, Vinay, I will tell you the best part is that anything you start, you should do it with, I would say, utmost dedication. Anything you do. I have a
Okay,
video
ma'am.
online. If you make a
Mhm.
wheel or you make a tea, do it with dedication. Which is good, nobody can decide for you or me also. It will
Okay, ma'am.
the I will say time will tell you what is good or what is bad. But one thing is in our hand, you and me both, or all of us here, all the people, that one thing, that whatever, even if I get an affidavit, small affidavit on caste certificate or the certificate as loss for police complaint, I should do it with lot of dedication. I should make it at my potential the best part. Now
Okay.
when you're even if I draft SLP, the same dedication for the Supreme Court also. So whatever you do it with utmost care, and see that you are handling clients case, and clients depend completely on you. So if you do your work better, it will open the next avenues also to you, and you will, I would say, you will shine slowly.
Thank you, ma'am. Thank you very much for that answer. And one more question I have, ma'am. while going through these examinations, I've got into the patterns, how a concept will evolve, right? So it starts from a basic thing and evolves into a fullest concept. So what if I want to focus or create a kind of new concept which I can introduce? So is there a way that I can
What
take
concept?
a concept as in let's say Cold War theory, like which will be applicable across all the cases, right? It starts from a very minimal thing and moves into a biggest blast it can be. So I'm trying to explore this kind of
You write it different to me in the chat box later on because I am not unable to get into it.
okay, ma'am. I'll write it, ma'am. I'll
Right.
I'll send
I'll
it
try
across.
to see if I can answer that.
Thank you, ma'am. Thank you very much for that. Yeah.
Anybody? Okay, then thank you so much. Shubharatri.
Thank you so much, ma'am. It's a very valued session.
Thank
Thank you
you,
so much.
thank you,
Thank you.
thank you, madam.
Thank you, thank you,
Valuable sessions.
thank you so much.
Thank you so much, ma'am.
That copies are सबके हम देखें.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you, thank you.
Thank you, ma'am. Thank you, ma'am.
Thank you, thank you.
Thank you, ma'am.
Thank you.
Hello. Hello. Ma'am, are you there?
Yes.
Good evening, ma'am. This is Naman. And
Okay.
ma'am, actually, I've been slightly wondering if there is any way possible where I can come to direct internship with you. Actually, I'm from Mumbai and
Call me tomorrow after 2:30. Okay. Not tomorrow, Monday. Okay.
sure, ma'am. Thank you.
Which place you are?
Ma'am, I'm from Delhi, but right now I'm in Mumbai. I'm in Vivekanand Law School.
Okay, okay. We'll speak. Okay.
Thank you, ma'am.